Different types of contracts. A verbal contract is a type of business agreement that is spoken and not memorialized in writing. A written contract, as the name suggests, is a contract whose terms have been reduced to writing. A distance selling contract is a contract concluded between a trader and a consumer under an organised distance sales or service provision scheme. It is made without the simultaneous physical presence of the trader and the consumer, and is made with the exclusive use of one or more means of distance selling communication up to and including the time at which the contract is concluded. In order for a written contract to be legally binding, the following principles must be followed. These principles must also be present within any other type of contract for it to hold any legal value. The written contract is a formal document. This details the agreement made, including the consideration and the terms and conditions between the offerer and the offeree. A written contract can also be drawn up after a verbal agreement has been made. These types of contracts are often signed by both parties to seal the agreement. A written contract is the most commonly found type of contract within the business environment. Having a business agreement formally recorded can be used to build trust and relationships between both parties. Having an agreement formally documented provides legal peace of mind. If one party breaches the contract, it should be easy to prove this in a court of law with the written document. This can then encourage both parties to comply with the contract and its terms and conditions. A contract can also be regarded as a communication tool. The document can also aid both parties in understanding their obligations and rights. Constructing a written contract can be complicated. As a result, additional costs are often incurred as legal advice and guidance is required. On the other hand, this cost is small when compared with the potential expenses of a court case. The process of creating and entering a written contract can also be timely due to this third-party assistance. A written contract can also limit an offer and be rigid. As the agreement is solely based on the content of the contract and nothing more, and both parties will only adhere to the terms and conditions only, or due to the costs and timescales of altering the contract, as these should always be updated within the written contract. A written contract also tends to be lengthy and complex. Either party may not fully understand the legal jargon within the contract and therefore may not fully understand their obligations, or the length of the document may deter either party from reading it thoroughly. This could lead to an overall breach of contract. Additional expenses are incurred as legal advice and guidance is required before entering the contract. The length and complexity of a written contract can overall deter one party from entering a contract altogether. A poorly drafted contract does not hold the same legal value or certainty as a well-drafted document does. It may also be difficult to judge their intention to create legal relations or the capacity of the other party if a written contract is formed without meeting or communicating face-to-face. Nevertheless, a written contract is considered one of the most secure type of contracts to hold. The same principles apply for a verbal contract to be legally binding. This type of contract is usually the easiest and quickest to enter. Both parties have the ability to negotiate, counteroffer and accept immediately, a process which can be timely in entering a written contract. The terms and conditions of the offer can also be discussed in depth and promptly, and both parties can clearly state their expectations of the agreement. Additionally, both parties can visually and audibly judge the other's intention to create legal relations and their capacity to enter the contract. A verbal contract is less likely to stand up in a legal court than any other type of contract. lack of legal recording of the agreement means it can be difficult to prove a contract even exists, or who is liable following a breach, as the terms and conditions are unrecorded to support the claim. It is often one party's word against the other. The terms and conditions of a verbal contract can also be open to interpretation. Either party can become unclear of their obligations or the terms and conditions of the contract. This can lead to a breach of contract or an unwillingness to adhere to the contract, knowing the difficulty of proving this within a court of law. A verbal contract can at any point be recorded into a formal written contract. This is most often recommended to avoid any disputes. Verbal contracts made on the sale of land or based on a credit agreement are not legally binding. The law states this type of agreement must be made in writing. A distance selling contract is usually formed online, via telephone or through mail order shopping. In line with legislation, the offerer must offer the following information pre-acceptance. Like a written contract, the agreement and terms and conditions of a distance selling contract are recorded and presented to the offeree. These, however, are usually found in a small print or through a redirected web page. When formed online, a tick box is usually required to certify that the offeree has agreed to the terms and conditions within the agreement. This ticking of a box or typing of a name is often referred to as an electronic signature. Entering a distance selling contract, especially through a click of a button, is relatively easy. When this is paired with small print terms and conditions, however, it can see a consumer agreeing to enter a contract unaware of its entirety. Following the formation of a distance selling contract, the offerer is then obligated by law to provide further information in a durable manner. For example, an email confirmation of an online order. If this is not given, a contract could be deemed as not legally binding. The distance selling regulations heavily protect either party of a distance selling contract. For example, the right to cancel a contract or order from the minute it is placed up until 7 days post receiving the item. Some organisations, such as New Look, offer an extended period. Distance selling contract is generally a one-size-fits-all standard, as the offer always remains the same. This can save legal costs, as advice and guidance is only required once. When considering the distance selling contracts made through third-party agents such as Amazon and eBay, the legal work is often completed for the offerer. The lack of physical and audible communication between both parties within a distance selling contract can mean it can be difficult to judge the other party's capacity to enter the contract, or either party's ability to deem the other's intention to create legal relations. Despite these factors, a distance selling contract is as legally valuable as a written or verbal contract.